Next, from Chicago, we hear a panel of women who've served on the Illinois Supreme Court. We'll hear about their careers and the changing opportunities for women in the law. But first, we'll see a portrayal of Myra Bradwell, the first woman to apply for an Illinois law license, and learn how the legal profession was once off limits to women. This panel was held during the mid-year meeting of the Illinois Bar Association. It runs about 1 hour and 15 minutes.
Judges of the Supreme Court of Illinois, now comes your petitioner, Myra Bradwell, and moves your honors that an order of this honorable court may be entered, directing that a license be given to your petitioner. Your petitioner suggests that the only question involved in her case is, does being a woman disqualify her from receiving a license to practice law? And so, in 1869, Myra Bradwell began her struggle to be admitted to the Illinois bar. Just 2 weeks later, she received the clerk's notice denying her application. Mrs. Myra Bradwell, Madam, the court instruct me to inform you that they are compelled to deny your application for a license to practice as an attorney at law in the courts of this state, upon the ground that you would not be bound by the obligations necessary to be assumed where the relation of attorney and client shall exist by reason of the disability imposed by your married condition, it being assumed that you are a married woman, until such disability shall be removed by legislation, the court regards itself powerless to grant your application. The Illinois Supreme Court regarded itself powerless, but Bradwell did not. She filed another brief. Your petitioner admits to your honors that she is a married woman, although she believes that fact does not appear in the record, but insists firmly that it is neither a crime nor a disqualification to be a married woman. The legislature has acknowledged the capability and capacity of your petitioner to transact business by providing that the Chicago Legal News, edited by her and containing the decisions rendered by your honors, be received into evidence in all the courts of this state. Your petitioner has complied with all the provisions of the statutes of this state regulating the admissions of attorneys, and asks, as a matter of right and justice, standing as she does upon the law of this land, that she be admitted. This honorable court can send me from its bar and prevent me from practicing as an attorney, and it is of small consequence. But if in so doing, your honors say to me, you cannot receive a license to practice as an attorney at law in the courts of this state upon the ground that you would not be bound by the obligations necessary to be assumed where the relation of attorney and client shall exist by the reason of the disability imposed by your married condition. You, in my judgment, in striking me down, strike a blow at the rights of every married woman in the great state of Illinois who is dependent on her labor for support. And you say to her, you cannot enter into the smallest contract in relation to your earnings or separate property that can be enforced against you in a court of law. This result can, in my opinion, only be reached by disregarding the liberal statutes of our state, passed for the sole purpose of extending the rights of married women and forever removing from our law the fossil footprint of the feudal system. The case is clear. After that, Bradwell wasn't quite yet done. She filed yet another brief, adding constitutional claims. The Illinois Supreme Court responded in a unanimous written opinion authored by Justice Lawrence. We find ourselves constrained to hold that the sex of the applicant is sufficient reason for not granting this license. It is to be remembered that female attorneys at law were unknown in England, and a proposition that a woman should enter the courts of Westminster Hall in that capacity or as a barrister would have hardly created less astonishment than one that she should ascend the bench of bishops or be elected to a seat in the House of Commons. It is to be further remembered that when our act was passed, that God designed the sexes to occupy different spheres was regarded as an almost axiomatic truth. It may have been a radical error, and we are by no means certain that it was not, but that it was the universal belief certainly admits of no denial. Our laws today in regard to women are substantially what they have always been. Whatever then may be our individual opinions as to the admission of women to the bar, we do not deem ourselves at liberty to exercise our powers in a mode never contemplated by the legislature. This step, if taken by us, would mean that all civil offices in the state may be filled by women, that women may be made governors, judges, or sheriffs. This we are not yet prepared to hold. The important question is what effect the presence of women as barristers in our courts would have on the administration of justice. And that question can only be answered satisfactorily in the light of experience. Application denied. As founder and editor of the Chicago Legal News, Bradwell responded to the court's opinion publicly. She wrote, "What the decision of the United States Supreme Court in the Dred Scott case was to the rights of Negroes as citizens of the United States, this decision is to the rights of women in Illinois. Annihilation." Bradwell didn't stop there. She took her case to the U.S. Supreme Court, represented by U.S. Senator Carpenter, who argued, "This record presents the broad question whether a married woman is entitled by the Constitution of the United States to receive a licensed practice as an attorney and counselor at law. This is a question not of taste, propriety, or politeness, but of civil right. In Cummings versus Missouri, this court say, the theory on which our political institutions rest is that all men have certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, and that in the pursuit of happiness, all professions, all avocations, all honors, all positions are alike open to everyone, and that in the protection of these rights, all are equal before the law. The conclusion from these cases is irresistible, that the profession of the law is an avocation open to every citizen of the United States. Now, let us come to the case of Myra Bradwell. Admission to the bar was denied the petitioner not on the ground that she is not a citizen, not for want of age or qualification, but upon the sole ground that she is a married woman. Can this court say that married women have no rights that are to be respected? Can this court say that when the 14th Amendment speaks of all persons and declares them to be citizens, that it means all male persons and unmarried females? I maintain that the 14th Amendment opens to every citizen of the United States, male or female, black or white, married or single, all the honorable professions as well as the servile employments of life, and that no citizen may be excluded from any one of them. Intelligence, integrity, and honor are the only qualifications that can be prescribed as conditions precedent to an entry upon any honorable pursuit or profitable avocation, and all the privileges and immunities which I vindicate to the colored citizen, I vindicate to our mothers, our sisters, and our daughters. The state of Illinois offered no response. Apparently none was needed. More than a year after Carpenter filed the petition, the U.S. Supreme Court issued its decision affirming the state judgment. Justice Joseph P. Bradley wrote a now infamous concurrence. The claim assumes that it is one of the privileges and immunities of women to engage in any and every profession, occupation, and employment of civil life. It can hardly be admitted as a historical fact that this has ever been established as one of the fundamental privileges and immunities of the sex. On the contrary, the civil law, as well as nature herself, has always recognized a wide difference in the respective spheres of man and woman. Man is, or should be, the protector and defender of woman. The natural and proper delicacy and timidity which belongs to the female sex evidently unfits it for many of the employments of civil life. The constitution of the family organization, which is founded in the divine ordinance, as well as the very nature of things, indicates the domestic sphere as that which properly belongs to the domain and function of womanhood. The harmony, not say identity, of interests and views which belong, or should belong, to the family organization is repugnant to the idea that a woman would adopt a distinct and independent career from that of her husband. The paramount destiny and mission of woman are to fulfill the benign and noble offices of wife and mother. This is the law of the Creator. Well, by the time the U.S. Supreme Court had issued its decision, the Illinois General Assembly had already passed a law allowing women to become admitted to the bar. But Bradwell never again applied for admission. Despite that, in 1890, the Illinois Supreme Court, on its own motion, granted her a license, nunc-pro-tunc, effective as of the date of her application more than 20 years earlier. Bradwell never practiced law. Instead, she devoted herself to the Chicago Legal News, the broader struggle for women's rights, and to her family. She used the paper as a bully pulpit to advocate reforms, including alleviating the travel burdens of the Illinois Supreme Court by its consolidation in a single location in Springfield and the creation of the appellate courts. She advocated increasing judicial salaries and requiring a jury trial for all insanity hearings. In 1889, Bradwell reflected on her 20-year career. During the long time my application was pending and its many ups and downs, I determined to put my legal education to some use. There was no paper then in the West devoted exclusively to law matters, and accordingly, I started the Chicago Legal News. My business had acquired such dimensions by the time the barriers to my admission were removed that I had no time to give to law practice, and I didn't care to be admitted just for the privilege of putting attorney after my name. All the wise makers of the land made doleful prophecies concerning the end of my career when I signified my desire to become an attorney by filing my application. They predicted that I'd wreck my family and break my hearthstone to smithereens. That was 20 years ago, and I know of no other family whose integral character is so unbroken as mine. Of our 4 children, 2 have lived and grown to maturity, and although both are married, we are all housed under one roof. I often wished all these excellent folk who used to picture me as the fanatic destroyer of domesticity and the sweetness of true womanhood could see my 2 daughters and our home life. Well, the time has now gone by when I wanted to be a lawyer, but the way has been made clear in all the professions for all women who care to enter them. And the world, too, has begun to learn the lesson that it is not necessary for a woman to break up all family ties and sacrifice womanly attributes and graces to succeed in trades other than the honored one of housewife. Upon her death, Bradwell was described as a woman who desired no reputation as a shouter of woman's rights. She came to plead for what her heart told her was just, simple justice for her sex. She heard the objections and answered them in an earnest, candid manner that made every member feel that she was pleading the cause of her own wife and daughter. quietly, nonetheless effectively, she set to work to remove the legal disabilities under which women labored. And for that, we are most grateful.
Myra Bradwell, as played by Rachel Sandel Morris. Thank you, Rachel. No one can say that Jenner lawyers don't perform. I'm John Simon. I'm chair of the Illinois Supreme Court Historic Preservation Commission. It's my pleasure to welcome you. The commission was created by an act of the Illinois General Assembly and made into law by the governor's signature in 2007. Its mission, in an abbreviated form, is to collect, preserve, and share with the public all manner of things relating to the judicial history of the state of Illinois. We would not be having today's program on women in the law without the extraordinary support given to us by Illinois Appellate Justice Carol Pope, who is the president of the Illinois Judges Association, John Lacallo, the president of the Illinois State Bar Association, and the collaboration of Bob Clifford, the president of the Chicago Bar Association. Assembled today are a group of extraordinary women who will take us beyond the fate of Myra Bradwell. Collectively, they are the firsts. Wisconsin Supreme Court Justice Shirley S. Abramson is the first woman to serve on that court and the first woman to be its Chief Justice. Illinois Supreme Court Justice Ann M. Burke is the first woman to have been appointed a judge of the Illinois Court of Claims. Illinois Supreme Court Justice Rita B. Garman is the first woman to be elected a judge of the 5th Judicial Circuit and a justice of the 4th Circuit Court of Appeals. Now retired, Mary Ann G. McMorrow is the first woman elected to the Illinois Supreme Court and also to serve as its Chief Justice. The Honorable Dawn Clark Netsch is the first woman to become a constitutional officer upon her election as Illinois Comptroller. And Illinois Supreme Court Justice Mary Jane Tice is one of the founders and the first woman to serve as president of the Illinois Judges Foundation. These notable women had the intellect and the courage to advance in the law and bring us to this juncture point in the history of women in the law. Now they will be sharing with us their views on women in the law, from Myra Bradwell's unfairly thwarted attempt to gain admission to the bar, to the empowerment of women as leaders in the judiciary, and to the question of what the future holds for women lawyers as they continue their quest and their efforts to gain equal access to the benefits and rewards their legal skills deserve. Now, during the program, if you have a question, there will be two of us who will be among the audience, and if you wish, raise your hand. We will give you a card. You can write a question, give it back to us. If there is time permitting, the question may be asked of the panelists. So our moderator for this event is Terry Mashrin, the immediate past president of the Chicago Bar Association, and she is going to facilitate our distinguished guests in exploring these issues with you. Thank you. Terry?
Thank you, John, and welcome everyone. We'll get right to it. Chief Justice McMorrow, when you started your studies of law at the Loyola Law School, you were one of 3 women in your class in law school. What happened to the other women with whom you started, and how did their experience influence how you approached your career?
I was delighted to have other women with me up until the last year of my law school. They, unfortunately, both of the other women who were in law school with me failed. One each year failed until I was the only one there. and it was a frightening experience in itself to see them fail. I always believed, because I got to know them well, that they had somewhat of an emotional approach to the law rather than the logical thinking that was expected of us. And I don't know what went on in their minds except for my conversations with them. And that led me to the conclusion that they, I think, approached the law in a different way than women did, which is unfortunate because they were two bright women.
Now, you then, to fast forward, eventually became the first woman to serve on the Supreme Court of the state of Illinois. Were you conscious of the fact that you were a first? And if you were, how did that affect how you approached the job?
Oh, I was very conscious of it because the media played it up. And everywhere I went, I was introduced as a possible first woman to serve on the Supreme Court. And the women's organizations supported me and emphasized the fact that I was not only a woman, but more importantly, that it was time for, it was overdue. It was time for a woman to be on the Supreme Court. So many of the issues that get to that court involve women just as much as they do men. There was really no distinction. So yes, how did it affect me? I felt great responsibility, perhaps more so than my colleagues. I'm not sure that they appreciated the fact that I believed I was being scrutinized extensively, because if I failed as the first woman, it would have been detrimental to all the women who followed me. It was very important to me and to the women that I perform well, and I really worked hard to do that.
Chief Justice Abramson, you have had a very long and distinguished career on the Wisconsin Supreme Court. You've served on that court since the 1970s. Have you seen a change in how women are perceived in the profession, and particularly, what effect do you think the introduction of diversity on the bench has had on the law?
Well, thank you for the question. Thank you for inviting me to Chicago to be here today. And I'm delighted to serve on this panel with all of these distinguished women. It has changed considerably. I was the first woman on the Wisconsin Supreme Court since 1848, when Wisconsin was admitted as a state. And we now have 4 women on the court, with the 3 men being the minority. And so looking around the table, it looks different, but the court acts the same in the sense that we look at the facts and look at the law and try and apply that law to the facts without a personal ideology, without looking at public opinion, without being influenced by either the executive or legislative branch desires, except as laws are passed, and without pressure from special interest groups. So it's very important that we maintain a neutral, fair, impartial, and non-partisan judiciary. I think we're all conscious of the fact that the legal profession, as well as all other professions, should be open for all, men and women, people of diverse races, religions, and ethnic backgrounds, people who are perhaps physically different, and that the professions and careers and job opportunities should be open to all. And those of us who came when we were minorities should be cognizant of that and have a helping hand to everyone else. That's what we're there for.
Justice Burke, Justice Abramson joined the Wisconsin Supreme Court in 1976. Where were you in 1976, and what was your path?
In the cradle.
Oh, no. 1976, I had just graduated from college. I was married and had 3 children, and my husband did a full court press in suggesting that I should go to law school because my background was working with children with disabilities, being a gym teacher and all. And so 1976, I started the application process without telling him because, goodness, if I applied and didn't get in, I surely didn't want him to know that. He's on a need-to-know basis even today. So I applied and I entered law school, and I had 4 children under 10, and by the time I finished, I was 40 years old. So I come to the court with a whole different perspective as a later, never a young lawyer, but a new lawyer, and learned with and became second chair with a number of wonderful lawyers, Sidney Karasik, some of you may remember, Pat Tewitt, and a number of others. I was fortunate enough to do trials with them. And my professor is the chief judge of the Federal District Court. My best grade ever was from Jim Holderman, and he keeps on reminding me that. So my perspective, I think, is just a little bit different. I'm still a recreation leader at heart, and I believe in collegiality. I believe in the words that are in the back wall of our courtroom, both here in Chicago and in Springfield, audi alterum partem, which means hear the other side. I think it's important to listen to everybody, not only your colleagues, and also in your family and your friends. So that's where I was.
Justice Garmon, you took a different path to the Supreme Court of the state of Illinois. Your first job was in a legal aid office. Why did you start there, and how did you then make your way through your career to the highest court in our state?
Well, when I went to law school in the 60s, women didn't go to law school, and you were considered kind of freakish. You must have had some strange background or ideas to want to be a lawyer. But I always wanted to be a lawyer, and I was fortunate enough to have a family that supported that, and my father believed as much as my mother that his daughters could achieve as much as his son. So I was encouraged from home, but anyway, when I went to law school and I graduated from law school, which was 1968, there were only 5 women in my class, and when I interviewed for jobs, they said to me, well, what would we do with you? And I said, well, I practice law. And they said, well, no one wants to talk to a woman lawyer, and particularly about sensitive matters of business or financial affairs. And things like, you're not really serious about this. You don't really intend to stay with it. I suppose you intend to have children. Well, yes, I do. Well, then you'll quit. Well, I don't plan to. So that was kind of the atmosphere that I found myself. And frankly, my first job came by happenstance because we had moved to Danville, where we live now, and my husband, who is a lawyer, had accepted a position with the firm he's still with. And I was looking around, getting these responses about my career, when the legal aid director walked out, and it was a one-man office. And at that time, it was locally run. It was funded by the OEO and the Office of Economic Opportunity, and they weren't sure whether they could maintain the office or not. So the chairman of the legal aid committee, who happened to be a partner of my husband's, called me up, and I think the conversation went something like this. You're not doing anything, are you? I'd been in Danville about 2 months, and I said, no. And he said, well, how about you come down and keep the doors of the legal aid office open? And we don't know whether it's going to be funded or not, and if it is not funded, of course, we'll close it up, and if it is, we're going to look for a director. And I said, oh, okay. And so I went down there for $90 a week. And I said to them, well, I'm a grass green lawyer. What do I know about running a law office and all the day-to-day operations of a law firm? And they said, well, if you'll come down to the legal aid office and keep it open, we'll help you. If you get into anything you don't know how to do, we'll be there. And that they turned out to be my mentors, and they turned out to be some of the most distinguished members of the bench, of the bar. And the judges were very good to me, and I found quickly that those people that came to the legal aid office, they didn't care that I was a woman, and they didn't care that I was young. And so I tell everybody, I learned to practice law like you learn to ride a bicycle. You just do it.
Justice Tice, when did you decide you wanted to be a lawyer, and how did you make your way?
We all have different stories. I was blessed that my father was a judge. And as a child, as a little girl, I loved going to court. I'd go to court and watch the drama that was playing out in the courtroom. And in those days, my dad was assigned to the narcotics court in Cook County. And it became very clear to me, maybe not so clear because I was young, but it certainly was very influential on my life, that on one hand, I saw that the people in his courtroom were people who were suffering terribly from drug addiction. Their lives had been destroyed by this terrible curse. And then their lives were also being affected in a very deep way by some of the most important decisions that were being made by the United States Supreme Court. This was the days of the Warren Court, and we could talk about the Fourth Amendment, we could talk about search and seizure. Those are the kind of discussions we had around the dinner table. But I could see the relationship between these abstract ideas and its effect on these defendants day in and day out that I would see in my dad's court. And very early on, I knew I wanted to be part of that discussion. Now, Mary Ann McMorrow was the first state's attorney woman at 26 in California back in the day. And I asked her what year she started. She can't quite remember. But the period I'm talking about is the early 60s, and there were no women role models for me then. But like others who have said this, my family were very much encouraging of me. And so from the very early part of my life, I knew I wanted to be a lawyer. When I went to law school, my husband was a year ahead of me, and when he began his classes, there were 7 women in his class. By the next year, when I started, there were 35. Now, you know, that's a lot more, 5 times as many, but certainly nothing like we have today, where almost 50%, if not more, of the law school classes are women. But I certainly, at each time in my career, I was at the beginning of the surge of women. I was a public defender, following back to my father's footsteps, back to 26 in California. At that time, again, I was not the first woman there. Mary Ann McMorrow had been there before me. But there were only 2 public defenders, myself and Sheila Murphy, who was here, and 2 state's attorneys, Lorna Probst and Patty Bob. So no, I was not the first, I was not alone, but again, day in and day out, in every courtroom I went to, I was the only woman in the room. I became a judge at 34. I've been a judge for 28 years. Please don't do that math. But anyway, when I became a judge a long time ago, 28 years ago, again, I was not the first. There were 18 judges who were sworn in the same time I was, and there were 2 women. So at every turn in my career, I've been supported by wonderful people, other women who were there for me. But day in and day out, as I did my work, I was alone. Like many here who've talked about how our careers developed, it was the men around me who were great mentors, who played wonderful roles in my life. I've often talked in public about what Tom Fitzgerald had meant to me from the very beginning. I met Tom when he was a state's attorney and I was a public defender. And from that very early time, he was someone who encouraged me and throughout my career to become a judge, to run for the appellate court, and just last year helped me take this place on the Illinois Supreme Court. I'm a person who doesn't believe in stereotypes, so I'm very hesitant to say the increase of women in the court system has done this or that, because not every woman lawyer is the same, nor is every man or every male lawyer the same. But I do believe that especially in shared decision-making roles that we have here, that it's real, that diversity is a very genuine thing. Being a judge means more than calling balls and strikes. There's a quality of judgment that we have to use. And that judgment, I think, comes from each of our life experiences. And women have different life experiences. And our voices add to the richness of the decision-making process.
Justice Abramson, that's a topic that you've written on a great deal and spoken on a great deal. What changes have you seen over your career as a jurist, and how do you think diversity affects the way courts decide cases?
Well, I agree with the previous speaker that diversity is very important. Now, I can't ever point to any particular decision that is so important that you attribute it to male or female. But in the entire body of discussing cases and in a collegial court, past experiences, diverse as they may be, make a difference. There was only one time in our court where the women, we then had 3 women and 4 men, where we lined up apparently by gender. And the only real reason I know that is because the media played it up. We didn't realize that while we were doing it. And it was a case in which, generally speaking, the trial court had ordered a male who failed to do child support, ordered him not to have any more children. Now, this is stated generally without all the ifs, ands, and buts. That's because he had many children by many different women and was supporting none. And the question came, was that a valid condition to place on him? And the men lined up and said, yes, it is. And the women lined up and said, no, it's not. Which is a strange kind of lineup if you're doing it by gender. But that's the only time that I can remember that. But the fact that there are women at the table makes a difference in the discussion. It makes a difference. And I think we've made a difference on courts by looking at issues in saying, is the court system working well on that? So we look at issues such as domestic violence, and we say, maybe there are different ways of handling domestic violence in addition to, as a supplement to the criminal justice system. We can say, shouldn't we do things differently when you have veterans come to the court who are suffering as a result of their service to our country? Should we just jail or imprison them without saying what is the cause or a possible cause of the criminal behavior, and should we do something? Should we alert the federal government that here we have a veteran who is eligible for help, mental health or drug addiction help? And I think that if you look at the history, at least at the state courts, you will see that the chief justices who are women have traditionally, in the Conference of Chief Justices, fostered programs that look at patterns of behavior that are co-occurrences with criminal behavior, and saying we shouldn't just have a prison system with a revolving door of having people come back, but that we should try and treat underlying causes. Now, prisons are very important for safety, and there are many prisoners who should be in prison, but there are others that we can be doing something for. And I think if you look at the history of the Conference of Chief Justices, we have women who have been leaders in saying, we have a system, we have some failures in the system, we should be doing something system-wide. And I think that's been one of our main achievements. And as others have said, this is not solely gender-based, and many of us have been helped and supported by our male colleagues. And so at the conference, much support by the men too.
And interestingly, the role as advocate for causes to improve society is very much in line with what Myra Bradwell did, and some of her contemporaries or near contemporaries like Jane Addams and other social reformers. So very interesting. Professor Netsch, you have a slightly different background. You've done many things in your career. You've practiced at a very large law firm, Covington and Burling in New York. You've held constitutional office in the state of Illinois. You've run for governor of the state, and for many, many years you have taught law at the Northwestern Law School. I'd like to ask you some things about your experience as a teacher. I know you have a first to tell us about that we haven't heard about, and then I'd like to ask you, what changes have you seen in the women law students who you've talked with and mentored over the course of your career as a professor, and what kinds of challenges do you think they still perceive that they face today?
Well, Terry, like every well-trained politician, I'm not going to answer your question.
I fully expect that.
I'm going to go on my message. You're right. There is one thing that I would like to add to this. You know, the program is named in honor of, and quite rightly so, Myra Bradwell, who was a pioneer, who was courageous, who did all kinds of marvelous things, and I honor her as well. I would like to add one more person to that mix, if I might. Someone probably most of you have not heard of, Ada Kepley. She also was a pioneer and a first. Ada Kepley was the first woman who graduated from a law school in this country. She received her Bachelor of Laws, her LLB, in 1870 from what was then known as the Union College of Law in Chicago, and this is just a part of my sort of self-serving aspect of this. Union College of Law then became Northwestern University School of Law. So we had the first woman graduate, and that was in 1870. Like Myra Bradwell, she was denied the right to practice. She was denied a license. In this case, her husband got uppity about it and challenged that and actually helped to bring about the enactment in the Illinois General Assembly, believe it or not, in, I think it was 1872, of a law that prohibited discrimination against women in the professions, including the legal profession. And Ada eventually then got her law license. I think it was in, not in 1872 when the law was first passed, but in 1881. And I think the other thing that's interesting, and this was certainly part of Myra Bradwell's life too, she did some practice, by the way, but she was also very active in reform movements, particularly those that involved women. She was a strong supporter of the suffragette movement. She was a strong supporter of equal rights for women in all respects. And all of those are things that I think all of us, as her successors, if you will, have probably continued to be very active. There was one other aspect, or one other reform movement that some of us have not been quite so active in, and that was the temperance movement. But temperance, remember, was very much a part of the feminist agenda back in those days. And so she was also very active in that. And I have one quote from her, which I will add. What she said at one point was, "I like to be at the front of great movements as far as possible." And she was, as was Myra Bradwell. So I think we owe her a debt of gratitude also. Now, what was your question?
My question was, have you seen a change in the attitudes of the women students who you work with and mentor and teach, and what kinds of challenges do you perceive they believe they're facing today?
The answer is yes, I have seen a change over the years. I actually started well, I started my own law school career as a student in 1949 when I was practically, well, actually in my graduating class, I was the only female. There were two of us who used to have a marvelous thing to say out on the campaign trail. There are only two faces that stood out in the graduating class of June 1952, Harold Washington and mine. For a long time, when the women were still not very plentiful in the law school classes, I think they were too timid. Nothing is universal. I mean, there are always exceptions to all of this. But I felt that they often sort of comfortably took a back seat. That is, they did not participate as much in class. They were not as aggressive in a nice, aggressive way. And I think some of it was that they just weren't sure what was ahead for them, because it was still a very male-dominated profession. Some would say it still is a male-dominated profession, and they didn't have quite the same hope and upward look that perhaps we would like to have seen in them. I've seen that gradually diminish, I think. Maybe not totally erode, but diminish over a period of time. And the women, I think, partly because there are just so many more of them now. I mean, there's no way for those who are hiring out there, who are still predominantly men, to ignore this. As I once said to some of them, if you want to have good lawyers in your law firm in the future, you better get over any thoughts of discriminating against women, because they're the ones who are going to be there, who are going to be the good lawyers. And I think they began to understand that. So I think in more recent years, the women students, and when I say recent, I think it really has been relatively recent, maybe the last decade. I'm not even sure it goes back as far as a couple of decades ago. The women feel more comfortable about their prospects. They are not as certain that they are going to be rejected and set aside. And again, in part, it has to do with the numbers and the change in the demographics, if you will, of the profession. So I think they do feel, as I said, more confident and a little more upbeat about what is going to... and the thing that I think is particularly important, at least maybe because of my time period, they don't, as they did for a while, I think, sort of carry a chip around on their shoulder saying, I'm a woman, you better treat me right. I think what they are now saying much more is the absolute truth. I'm not a woman lawyer, I'm a lawyer, and you better treat me that way.
Justice Tice, do you still perceive that there are challenges for women in the practice of law today?
Yes, yes, and yes. I can't tell you how often I have this phone call. Some young woman lawyer calls me and says, can I have lunch? And I thought, I know exactly where we're going with this conversation. I go to lunch with a wonderful young lawyer, and the wonderful young lawyer says to me, Judge, how did you raise your children and still be able to practice at this level? And I think to myself over and over again, why haven't we figured this out? Why is this still the same recurring problem? In my own life, when I first was pregnant when I was a public defender, I went to my supervisors and told them I was going to have a baby, and they were floored because, of course, no lawyer had ever had a baby before. It just didn't work, you know. And they told me that I had to quit. And I kind of had to take a lot in my life there. And then sometime later they said, probably they figured this out, they said, you know what, we changed our mind. Do whatever you want. You know? Then when I came back again and was pregnant again, oh my goodness, these people keep having babies. By then, they figured out they needed a maternity policy. But you'd think that through these years, we would have worked this out so that women could have their families and still continue in the practice. What concerns me is well, yes, there are wonderful examples of people in this room who are able to achieve great things, women who are able to achieve great things, we see in the large law firms that women, the number of women who become partners is dramatically different from the men who become partners. And it seems to be the fact that at a certain point, women in their childbearing years take a different tact because of the culture of the law firms. And we have to figure out ways to address that. I think it's just key. Now, I'm going to give a pitch to Deanne Brown, the current president of the Women's Bar Association. I know this is her issue, and she's been working very hard on this. But I think it's something that's important that we need to all talk about. I was very fortunate that right when my children were little, like 1 and 2.5, I think, I became a judge. And like most judges, I started my career in traffic court, the kind of places where you work all day, you don't take a break for lunch to go to the bathroom, you talk constantly, and then it's done at 4 o'clock in the afternoon, and you can go home and there's no homework. And so it was a good way for me to be able to have my kids when they were little and still be able to work. But most people don't have those kind of opportunities, and we have to find ways for younger women to be able to find a way to balance. Now, certainly that's an important issue for young men, too. I think that we've also seen that older people of my generation, the men just kind of took it for granted they were going to be lawyers and they're never going to see their kids. That's not true today. Young men also want to be part of their families, and they want to find that balance as well. But the actual time of the childbearing and rearing, I think we still haven't figured out how to retain wonderful young women lawyers through those years into the rest of their careers.
Justice Garmon, what's your view on that subject? Do you think that the perception of women in the law has changed over the course of your career? And do you see challenges that women lawyers still face today?
Yes, I have witnessed tremendous change since I first became a lawyer. And I think there's much change that still needs to occur. I would certainly agree with Justice Tice on where we need to be as far as figuring out how to make the practice of law more user-friendly for all the attorneys that are involved. And I think our society and culture have changed, and I think parents are now more involved in the child rearing than they were in past generations. It's a two-parent operation rather than just with mom. But I don't think that the traditional idea of how you practice law in big firms with men necessarily works with women. And I don't think that's a bad thing. I think it means we have to be more creative, because the brain power, the analysis, the work ethic is still there. It just has to be addressed in a different way. And I often tell young women today, when I began the practice of law, the discrimination was overt. I mean, there was no doubt when I interviewed with places and they said to me, how many children do you intend to have? What kind of birth control devices do you use? And people are outraged with those kinds of questions. Of course they wouldn't ask those questions today. Are they still curious? I think so. I think I still think there's some residual concerns there, and I think that I think time will address many of those things. But I think younger practitioners today have to realize that just because it's not on the surface doesn't mean it's not there.
Okay. Justice Abramson, you're responding.
I agree with what has been said, and there are two great hopes as I see it. One is that the young men in the firms have the same problems, and they have wives who have careers too and have to balance out the wives' careers. And I'm hoping they'll join up with the women and say, here's how we're going to have to face family and career, which we all have. And the second great hope is that the male partners who are the dominant partners are having daughters, and their daughters are having careers, and their daughters say what the experiences their daughters are having. And the one thing these guys don't like is discrimination against their daughters. And so the guys who discriminated against me 20 years later, were my best allies because their daughters were out in the field, whether they were real estate brokers or accountants or lawyers or what have you, and no one was going to discriminate against their little girls. And so I'm not urging that you sit back and just accept time, but I am saying that you should recognize this, but that it's important that we all join together and say families are important, and that so are our careers, and so are serving the people or serving the clients. And of course, being a judge is the best thing because the black robe covers everything. There's no heavy lifting, and you can put your feet up on a stool, and there you are, ready to go. We have to just urge all these women to become judges.
Does that mean you can wear sensible shoes too?
You can wear shorts. The robe covers everything.
Justice Burke, you have written that, that women bring a nurturing human awareness to the practice of law. What do you mean by that? And do you think there is an inherent tension between women fulfilling the challenge of bringing civility to the practice of law and yet fulfilling their legal obligation to their clients to be a zealous advocate?
Wow. When did I write that? I think that there's no difference. I mean, I wouldn't separate all those elements away from the human being. Men have aspects about themselves, the way they were raised, their religion, what they believe in. It's all part of you. And so I think women and men alike both have that nurturing aspect as well. It's just that I think because of the experience of women in ways in which men haven't until presently been able to be nurturers as well. But I have two daughters that are lawyers, and I have a son-in-law that's a lawyer. My husband's a lawyer, and I find that they've all taken different paths in their lives, and they've been able to balance, as my colleagues have talked about, what it is about life and what's important to them, and what is important to them is family. And the work isn't the most important thing to them, but they love their work. But I think the aspect of the nurturing piece comes because they have experienced outside of the law a real world in which they live in their community. They've experienced the pro bono work, their church work, and other things, and that comes across within the law. So I think based on their life of themselves and how they were raised and their religion and their life, community work is a true basis for why they are better lawyers. They're advocates, they're human beings, and they have empathy. And as to law schools, helping young lawyers, men and women, understand this is a mandate that they should really think about, is that the practice of law is very important, but lawyering and being a lawyer in other fields is spreading the word. And it's the opportunity to do lawyering in other areas, and especially in today's world of hard times. I think the diversity, or I should say, the problems we have in the world now in terms of jobs, it is causing people to look outside of the box for areas in which to work. The Legal Aid Society, their church, and free legal work will help them become a better lawyer when things are better.
May I
Yes, sure.
say this? When I was a lawyer practicing in Madison, I was expecting a child in September, and we were scheduled for a court case in September. And so in June, I went to see the clerk of the Supreme Court and asked that we put it over till October, and that I had the permission of my clients and opposing counsel to put it over. And he said no. And I said, well, I know that in deer hunting season. And he said, well, you know, that's a season and they only have the week or whatever it was, and I'm not going to put it over for you. Just have the baby early. Well, I just was not going to have the baby induced to appear, but I have a very obliging child, and he's very good then, he's very good now, and he did come early. But I looked at him, and I never expected to be on any court, and I thought, this is no way to run this ship. And so when I did get on the court, and now I do have scheduling powers, I am very careful to allow that lawyers have lives, and they do take vacations, and they do have children, etc. And I plan for that. On the other hand, if I think that I'm being used and manipulated for ill purposes, I say no. But I think that we have to understand that and take care of that.
Would you tell us why it was that you chose to start your career there, and what were your experiences like as one of the very few women in the office at that time?
Well, I chose to practice, excuse me, as an assistant state's attorney because I was very interested in doing trial work. And I knew that the state's attorney's office provided an opportunity to be on trial each and every day, one case immediately following another. So the experience was such that it could not be beaten in any other place. I was invited. Now, I had been, as you know, the only woman in my law school class, yet my colleagues were very, very supportive of me. I was elected class president, and I was also elected to law review. And when I graduated, a large, prestigious law firm invited me in for an interview. And I went, and I wasn't there but a few minutes when the attorney who interviewed me said, I want you to know that we do not have a woman attorney working here. We have never had one, and we never will. And I got up and I said, thank you, but I wouldn't want to work here under those circumstances. I have followed that law firm since that interview, and they now have a lot of women working there.
I hope it wasn't mine, Justice.
No, it wasn't. But I often wondered if that old goat is still there, really. He's not, really. But I forgot the question, too, now.
What were your experiences? You joined the state's attorney's office. You were the first, I believe, woman trial lawyer in that office. What was that experience like?
Wonderful. It was absolutely wonderful. I loved every day that I worked there. In fact, I have really loved almost every day of my entire law career. There's much joy to be found, as well as many challenges to be found in practicing law. I think we all have the ability to accept those challenges if we do it with the right attitude. I was never contentious. Rather, I chose to persuade by talking things out, by collaboration, rather than being contentious. I didn't flaunt the fact that I was the only woman because I wanted then, as I still do, to see the day when litigants, lawyers, anybody who comes into the courtroom won't even notice that there's a woman on the bench rather than a man. To me, that's Americana. That's what it should be. It's a little bit more than diversity. It's accepting the fact that being a woman judge, or a judge who happens to be a woman, is every day. So what? It's everyday matter, really. And we should not distinguish between them. I don't think that we should try to usurp their powers and all of that, but do it by not being contentious, but by collaboration. There's much willingness on the part of the people who opposed us to now accept us for various reasons which were beautifully articulated here this morning. I think we're in a different position now than we were many years ago. But I do think that along the way, the women, these ladies who worked in the profession and who worked in the law, helped make it what it is today. And really, today, there is no area of the law, airplane crash cases, serious antitrust cases, women can now practice in those areas. Before, they were relegated to probate, traffic court, and children. Right. I agree with everything these ladies have said, and I think their observations were inspiring, really. I think that my work in the state's attorney's office did help to bring me to this point where I am now in my thinking. It was not always that way, but you have to be tenacious. You have to be willing to work for what you believe is correct, and that is the diversity, the women in the profession, and so forth. And I think you have to search for opportunities. It's important that you keep your minds open and see an opportunity when there is one there for you. And I think we probably would be accepted if we did find an opportunity and try to obtain or get something that heretofore had not been gotten. And most importantly, and this was referred to before, is I think we always have to be nice. Simple word, but most important. It'll get you very, very far. Thank you.
Justice Burke?
I just wanted to mention about Justice McMurrow, who's too humble and modest to mention, but she wasn't always accepted in the state's attorney's office. There was an occasion when she was a felony trial lawyer and practicing. For those people if many of you don't know, she was practicing and actually preparing for an argument in the Illinois Supreme Court, and her supervisor, a male, said to her, "Mary Ann, what are you doing?" And she said, "I'm getting ready for the argument in the Supreme Court." And he said, "No, women do not argue in the Illinois Supreme Court." So Justice McMurrow, and we all know, ran to be the first woman on our state court, but this is in our lifetime, so things still happen, and we have to be ever vigilant. Thank you for all that you've done.
Thank you,
Professor,
can I just say one
sure.
thing? Thank you, Justice Burke. My colleagues like to tell that story about not being able to argue before the court in which I became the Chief Justice. By the time I became the Chief Justice, however, I looked for that same man, that same supervisor, and he was gone to his eternal reward or whatever he was getting. I'm not sure what he was going to be getting, but when he passed away, I went to his wake, not so much because I felt sorry for him, but because I wanted to make sure he was gone. And he was. The men have been very good to me. I do not think we should alienate that big group of people, all the men who practice law, all the men who have cases, who are corporate lawyers, whatever. I do think we should work together.
Professor Netsch, you have worked in the private sector at a law firm. You've been in government. You've for many years been a professor of law. Have you seen differences in the attitudes toward women lawyers in those different spheres, and to what do you attribute those differences?
I think really in almost any area of activity, I've been around a long time, and I've had an opportunity to see a change in the attitude toward women, and to some extent, as I was expressing before, a change in attitude on the part of the women themselves, feeling they had a different role in life than had been described for them for a long period of time. It's been generally a slow evolving process, and I think that's true whether it's in practice, in academia, in the court system, and certainly in politics. Probably tougher in politics than in some of the other areas. What you see happening is that you start off a little bit with tokenism. Especially, well, in law firms, I think that was happening. It certainly was happening in academia. Gee, we've got to have a woman on the faculty because we got so many women students now. In politics, it was the fact that more women vote than men. Somehow that message got through to those who were controlling the process, and they decided maybe they ought to have a woman around. Now, the woman might not be a lawyer, and in the earliest days probably was that. I think I may have been the first woman lawyer in the Illinois General Assembly, and that, obviously was within my lifetime anyway. And now there are many more, but it's not quite as critical a thing now. I think there was a respect, sort of innate respect for a woman, whether it was in the political realm, who was a lawyer. They were just a little bit awestruck and maybe a little intimidated. That I think is past, and I think the women sort of meld together now, whether they're lawyers or not, in the political process. The thing that is absolutely, although it's still, by the way, a very distinct advantage, I think, being a lawyer in a legislative body, for example. I think the thing that has been extremely important has been a recognition. First, a little bit of it comes from the heart. Maybe we shouldn't be discriminating against all these females, whatever they're trying to do. I think some of it was very pragmatic. I think that was true, as I indicated, really in practice, in academia, and certainly in politics. There are so many women out there, and they are not the same as their mothers and grandmothers were in terms of their lifestyle, and we better really recognize it and respond to it. And I think that some of it has been, as I say, a very pragmatic response. I would like to think it all came from the heart, but it doesn't always. And I think that in turn has sort of erased the lines, so that what started out to be maybe we've got to have a woman for a token, it became a little more comfortable after a while. And I think that's certainly true in practice. It's true among the students. I think the male students, I don't see much resentment of their female colleagues in law school anymore, and I did in the 70s, maybe even into the 80s. And in politics, that is also true. A lot of those guys are getting more comfortable with the fact that women do have different roles, and they play those roles very well. And I think the thing that I've heard really everyone here say in their particular context, I would absolutely emphasize with respect to the world of politics. That's where so many of the decisions are made that affect the lives of everybody. Whether we like it or not, it is absolutely true. We decide the criminal law, we decide the domestic law, we decide everything really in legislative bodies. And I can't tell you how important it has been and how critical it is to expand on the number of women who are at the table helping to make those rules. It really has made a difference.
Justice Abramson.
Professor, you've touched on a very important point. That is, when we talked about diversity, we talked about decision-making by us and diverse. But it's just as important that people who come to court see that the courts are made up of the population from which they come, and that the court system and government as a whole looks like the people, that is just diverse. And so that they're in at both ends, the supplicants as well as the decision makers. The other thing I wanted to say is that we owe, all of us, each of us, a great debt to the women who came before us and opened the doors. The Myra Bradwells, the Lavinia Goodell, who was our Myra Bradwell in Wisconsin, to the civil rights movement of the 60s and to the women's liberation movement of the 70s. These all opened the doors for the concept that we ought not to be stereotyped, and we ought not to stereotype others, and that we ought to be judged on our own individual merit. And I am quite confident that without these movements over the years, the governor of the state of Wisconsin would not have appointed me, but that these political movements allowed him as a political figure to make that appointment. And Governor Patrick Lucey of Wisconsin is alive and well, and I send him flowers every March on his birthday.
Thank you. And I think that brings us full circle to the historic context of this program. I would like to thank all of our wonderful jurists and Professor Netsch for being with us here today. What a rich opportunity to hear from such an impressive group of women, each of whom in her own way has always been an idol of mine and a role model, and I think can be for all of us, whether we're male or female. Please join me in thanking them.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.